the trial that almost broke the U.S. Constitution. No one noticed the moment it began. There was no explosion, no siren, no breaking news alert scrolling across television screens. It started quietly, buried inside a routine court filing on a gray morning in Washington, D.C., when the marble halls of justice echoed with nothing more than footsteps and whispered conversations. Yet historians would later agree on one thing with chilling certainty: this was the day the United States Constitution came closer to collapse than at any time since the Civil War. At precisely 8:47 a.m. a federal clerk stamped a document that would ignite a constitutional crisis unlike anything in modern American history. The ink dried fast, but the consequences would not. Within weeks, the nation's legal system, its democratic norms, and the fragile balance of power between branches of government would be pushed to the brink. This was not just a trial. This was a stress test of the American experiment itself. The defendant was not a criminal mastermind hiding in the shadows. He was not a foreign enemy or a faceless corporation. He was a sitting federal official, shielded by authority, protected by precedent, and surrounded by advisors who believed, some sincerely, others opportunistically, that the Constitution bent in his favor. The charge was simple on paper and explosive in reality: abuse of federal power during a declared national emergency. From the very first hearing, the courtroom felt different. Veteran reporters sensed it. Constitutional scholars leaned forward in their seats. Even the judge, a man who had presided over terrorism cases and organized crime trials, paused longer than usual before speaking. Because everyone in that room understood the unspoken truth: if the court ruled one way, it could permanently weaken the presidency; if it ruled the other, it could quietly crown a president above the law. Outside, the nation remained largely unaware. Morning talk shows debated celebrity scandals. Stock markets ticked up and down. Social media argued over cultural flashpoints. But inside that courtroom, lawyers were dismantling assumptions that had guided American governance for more than 2 centuries. The prosecution opened with documents verified, authenticated, sourced from public records, and classified briefings later declassified under congressional order. Emails, internal memos, recorded calls. Each piece painted a picture not of a sudden mistake, but of a calculated expansion of executive authority justified under the language of national security. The words "temporary measure" appeared again and again, yet the actions taken had no expiration date. The defense countered with a doctrine older than television and stronger than any statute: executive immunity. They cited Supreme Court precedent, wartime decisions, and historical moments when presidents acted first and asked permission later. Lincoln, Roosevelt, Truman. The implication was clear: this was how America survived existential threats. Questioning it now, they argued, was not just legally reckless but dangerous to democracy itself. That was when the judge asked a question that would later be quoted in law schools across the country. "If emergency power has no clear boundary," he said slowly, "then at what point does the Constitution stop being law and start being a suggestion?" Silence filled the room. The question hung there, heavy and unresolved, because no one, not the lawyers, not Congress, not even the Supreme Court, had ever fully answered it. As the trial progressed, the nation began to notice. Breaking news banners appeared. Primetime anchors used phrases like unprecedented, historic, and constitutional showdown. Polls showed Americans deeply divided, not by party alone, but by their understanding of freedom itself. Was liberty protected by strong leadership or restrained power? Was security worth unchecked authority? Could the rule of law survive when fear dictated policy? Witnesses testified under oath, their voices steady but their words explosive. A former intelligence analyst described pressure to alter threat assessments. A senior legal advisor admitted that certain actions were taken precisely because courts had never ruled on them before. A military official revealed that orders had been issued verbally, leaving no paper trail until now. Each testimony added weight to an already strained system. Protests erupted outside federal buildings. Think tanks released expert analysis. Law professors flooded op-ed pages with warnings about long-term consequences. Foreign governments watched closely, aware that America's credibility as a champion of constitutional democracy was on trial alongside the defendant. Behind closed doors, Supreme Court justices began preparing for the inevitable. Everyone knew the case would reach them. The only question was whether the country would remain politically intact by the time it did. The most dangerous moment came not from a witness or a ruling, but from a delay. A procedural delay. A simple request for more time. Markets reacted instantly. Cable news spiraled into speculation. Social media amplified misinformation. In that vacuum, trust already fragile began to crack. And that was the real threat. Because constitutions do not collapse only through coups or violence. Sometimes they erode through ambiguity, fear, and the slow normalization of exception. This trial exposed something Americans had long avoided confronting: the Constitution is not self-enforcing. It survives only if people, judges, lawmakers, citizens choose to defend it, even when doing so is inconvenient, unpopular, or terrifying. As closing arguments approached, one truth became impossible to ignore. No matter the verdict, the United States would not emerge unchanged. Either the presidency would be forever constrained by judicial oversight, or executive power would gain a precedent so broad it could reshape the republic for generations. On the final day, the courtroom was packed. Cameras were barred, but history was present in every breath, every glance, every trembling hand clutching legal notes. The judge looked out over the room, fully aware that his ruling would be studied, debated, and challenged long after his name faded from headlines. This court, he said, is not deciding the fate of one man. It is deciding how close power may come to the edge before the law pulls it back. When the gavel finally fell, America held its breath. Because the trial was over.